Straight ahead on Law and Crime Daily. A verdict is handed down in Vanessa Bryant's lawsuit against Los Angeles County. Hear how much the county is ordered to pay in the California trial. And
Clear what Paul wanted, and it seems equally clear that they're not doing that.
the daughters of the late Paul Newman are suing the foundation named after the philanthropist, alleging it hasn't followed their father's donation wishes. Plus, the attempted murder and kidnapping trial of Trevor Summers.
Were you worried about your mom or Trevor?
Yes, very.
The defendant's daughters testify in a Florida courtroom. And later, things get heated in the trial of Ohio versus Matthew Moore.
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward.
Law and Crime Daily, covering court cases from coast to coast. Welcome everybody to Law and Crime Daily. I'm your host Allison Hall, in for Brian Buckmeyer. A California jury orders Los Angeles County to pay $31 million in damages after first responders took graphic photos of the Kobe Bryant helicopter crash. After only 4.5 hours of deliberation, jurors awarded Bryant's widow, Vanessa Bryant, $16 million and $15 million to Christopher Chester, whose wife and daughter also died in the crash. Together, Bryant and Chester brought the civil lawsuit against Los Angeles County, arguing first responders took graphic photos at the crash site and shared them with others outside of the police and fire departments. The photos show images of the crash itself and also close-ups of the victims' remains. Kobe Bryant and his daughter Gianna and 7 others died when the helicopter crashed back in January 2020. Both Bryant and Chester testified during the trial, saying the photos caused emotional distress and feared that one day they would be easily accessible. In the end, jurors found the Los Angeles County Sheriff's and fire departments lacking protocol, resulting in a violation of rights. Joining us today is co-host Harry Austin and former SWAT and crime analyst Lisa Lockwood. Lisa, let's start with you. The jury determined first responders lacked protocol when they managed that scene. What type of protocol should have been in place to protect these families' rights?
Well, there is a protocol in place for any crime scene, accident scene, that you are to render aid first and then preserve the crime scene. And we know that there were brush fires that day as well. So if you wanted to take photographs before a forensic team came over there and did that in order to preserve it, it's perfectly okay. Anything beyond that, taking pictures for your own personal use, distributing them, showing them to people in casual settings, it's a complete moral breach, because police and first responders, their whole entire job and career is based on serving and protecting. So it's a violation of their conduct being unbecoming, and protocol is set for that. And I really pray that this sets a precedent for all law enforcement and first responders going forward to not do this.
And Terry, the jury awarded Vanessa Bryant $16 million, but Christopher Chester $15 million. How do you think they accounted for that $1 million difference?
Allison, that's a great question. And unless we actually speak to one of those jurors, we're not going to know for sure why they did that. But in my opinion, each of them should have received the same amount. Emotional distress is emotional distress. And both Brian and Chester, they lost a spouse and they lost a child. And Chester, just like Brian, had other children to raise. In fact, he testified at the funeral that he told his wife he would take care of the boys if she could take care of Peyton. So that's emotional distress, and I think that they probably should have gotten paid the same amount. Maybe they did it because she's famous and the pictures might come up.
Yeah, it is a very tragic story. Hopefully that brings some peace to these families. Switching now to Florida, where the defense calls back-to-back psychiatrist witnesses in the Parkland school shooter penalty phase trial. In February 2018, a then 19-year-old gunman opened fire at Marjorie Stoneman Douglas High School in Parkland, Florida. 17 people were killed and 17 more injured. In October of last year, the gunman pleaded guilty to all charges. That means a jury will now decide whether he is sentenced to life in prison or receives the death penalty. Weeks after the trial began, the defense presented its opening statement on Monday. Before court recessed early on Thursday, defense attorneys called 2 psychiatrists who discussed the childhood and mental state of the gunman.
Are you familiar with fetal alcohol spectrum disorder?
I am.
Okay. And if you had learned of any prenatal alcohol exposure, that wouldn't have changed your treatment plan for the defendant, would it?
Not really. You still medicate the symptoms you're seeing regardless of what the etiology
You're treating the behavior.
is. Yeah.
And did you get the impression that Linda was doing everything she could to help the defendant?
I did.
And obviously you learned what happened on February 14th, 2018.
I did.
And do you think there's anything about your evaluations or treatment that would have led you to think that the defendant would kill 17 people?
No.
Still ahead on Law and Crime Daily, a Florida defendant cross-examines his own daughter after electing to represent himself. But first, Paul Newman's children file suit against their father's company, arguing their father's legacy is under assault. Welcome back. Two daughters of the late actor Paul Newman are suing the charity foundation set up in his name. Susan and Nell Newman say the foundation isn't abiding by their father's wishes when it comes to giving money to their charitable organizations. Law and Crime's Anjanette Levy is here to explain.
Allison, you know, we've all probably seen Paul Newman's own products at the grocery, things like salad dressing and spaghetti sauce. And the money from the sale of those items goes to charity through the Newman's own foundations. But Susan and Nell Newman are saying that their charitable foundations are supposed to get money from Newman's own foundation every year so they can distribute it to charity. And they say that hasn't been happening. Now, Paul Newman set up Newman's own foundation in 2005 and laid out instructions about how he wanted it run. The Newman sisters say their foundations are supposed to get $400,000 each year from the Newman's own foundation. But in 2020, that amount was cut in half by the board of directors of the Newman's own foundation. Now they're suing, claiming a breach of fiduciary duty, and they want $1.6 million so their foundations can get that money in order to distribute it to charities of their choosing.
Starting 4 days after Paul died, is that, you know, the leadership and the board of the foundation has, you know, in large part excluded the family and the very people that Mr. Newman had directed to be specifically involved in very particular ways, excluded them from the implementation of his legacy, which is in large part through the foundation.
Now, a spokesperson for the Newman's Own Foundation calls this lawsuit meritless and said in a statement to me, "The board's philanthropic giving decisions vary each year, and the importance of our mission requires us to make the best use of our finite resources. Best practices surrounding philanthropic organizations do not allow for the establishment of perpetual funding allotments for anyone, including Nell and Susan Newman." Now, the attorney for Nell and Susan Newman say, look, this money is supposed to go to our charitable foundations. This is what our father wanted. And they say that this is not a meritless lawsuit. Allison?
Thanks, Anjanette. Terry, let's go to you here. It sounds like there were a number of documents expressing charitable wishes, but apparently nothing was firmly memorialized. Do you think that the daughters have a chance at all in this case?
Well, I think they have a chance, and it all depends on whether or not that case is going to be determined by the law completely or whether or not there'll be some equitable considerations. They did ask for a jury who I think might look at this more equitably, but according to the complaint, Paul Newman did express his wishes in letters and emails and videos, but it doesn't seem as though the living trust and the last will and testament actually made that clear. And so the foundation really can control how it gives and how it runs its company. And it's a difficult situation for those daughters to be in. They know what their father wanted. So hopefully they'll be able to reach some sort of settlement at the end of the day so both sides can end up with what they need, one, running the company, and two, making sure that Paul Newman's wishes are really addressed.
And Lisa, what more do you think could have been done to enforce Mr. Newman's wishes and give more control to his daughter over that foundation?
It's as simple as a contract. So this new organization that took over the Paul Newman Foundation, the contract that was sent to them, they needed to make sure that it was in there that there was going to be a certain amount. If you have this company coming forward now and saying that it's meritless based on how much the income is and how much they received prior to that, listen, 2020 is when we had the pandemic. So it makes perfect sense if you open up the books that you're going to see less sales for products, and this happened across the country. So unless it's in stone, and being in stone means there is a contract that says that they will receive X amount per year regardless of, the family probably wouldn't have a leg to stand on.
And Jeanette, if Newman's Own Foundation has been around since 2005, Paul Newman died in 2008, and the family has felt excluded since then, why do you think the sisters took so long to file this lawsuit?
Well, their attorney, Andy Lee, said that basically they were fearful for a little while that they would be viewed as contesting the will, because apparently there was some language in Paul Newman's will saying basically you contest this will, you're out, you get nothing. But they maintain that this isn't money for them. It's for their charitable foundations, and that they want to distribute it as their father wished and as their father wanted them to receive these funds to their foundations.
Thank you, Ann Jeanette. Coming up on Law and Crime Daily, fireworks in the courtroom when a prosecutor storms out of an Ohio murder trial. Plus, a defendant accused of kidnapping and attempted murder opts to represent himself. Cross-examination gets tense when he questions his own daughter. Welcome back. The defendant's daughter testifies in the Florida trial of Trevor Summers, a man now representing himself against charges of kidnapping and attempted murder. Prosecutors say 45-year-old Trevor Summers kidnapped his wife back in 2017 and attempted to kill her before a witness facilitated an escape. Officials say Summers and Elisa Mathewson were in the midst of divorce proceedings when he allegedly plotted a murder-suicide plan. They say Summers held his wife captive in her home and the back of her SUV, attempting to kill her twice and raping her several times. Summers allegedly pulled the couple's daughter, who was 14 at the time, into his scheme when he asked her to leave a window at Mathewson's house open for him to get in. Her sister, Bryn, who was around 7 years old at the time, took the stand on Thursday. She testified she was worried for both parents that night, but didn't fully understand what was going on.
Were you worried about your mom or Trevor?
Yes, very.
And why were you worried?
I just didn't understand what was going on until after. But yeah, I didn't understand what was going on. But, yeah.
Could you hear what was being said between your mother and Trevor?
I do not remember. Just a lot of screaming.
Do you remember, Ms. Bryant, if I was yelling anything back at Mommy?
No.
Do you remember if I was saying anything at all?
No, I don't remember.
The state rested its case Thursday afternoon. Summers indicated he may testify as a defense witness and will decide before Friday morning. Terry, Bryn was only 7 years old at the time of the incident, and now she's 13. How do you think she held up on the stand?
I think she did a great job. She's still a minor, so there was no camera on her, but she sounded so young, even at the age of 13 now. She didn't really remember that much, but I do think she made a couple of points. First of all, she called her father Trevor, and to me that means she certainly is not siding with him, and she certainly doesn't really think of him at this point as her father. One of the things she also clarified was she said that the mom was yelling, and I do think that Trevor was trying to make it seem as though she was yelling and she was mad, but she made it clear on that stand that her mother was yelling because she was scared, not because she was just yelling at her dad. And I do think that she overall probably made an impression on the jury. Last but not least, the defendant said, "Good to see you." I got to tell you, that was inappropriate, and the judge gave him a glare, and he best not do that again. He can't mix up his role as an attorney and as a father.
Yeah, absolutely. Lisa, let's turn back to Trevor Summers. If he decides to testify, how exactly would that work?
Believe me, I've thought about this because I haven't seen this. I haven't seen it in my lifetime. The first thing that I thought of was ventriloquism, because how is he going to ask himself questions? But obviously he's got a co-counsel who is there. I would imagine that he has pre-written questions and they would go over everything that he would like to have come out. But as far as the objections, because he is he's representing himself, and if he's under direct, is he going to be able to object to some of the questions based on that? I don't know, but I'd like to see him take the stand.
I think a lot of people would, with him representing himself. It certainly is making for an interesting trial. When we come back, a heated start to the day in an Ohio courtroom, ahead of both sides resting in the case of Matthew Moore as he stands trial for the staged suicide of his wife. Welcome back. In Ohio, things got a little heated in the courtroom before the defense began presenting their case for the day in the trial of Matthew Moore, as he faces murder charges for the alleged staged suicide death of his estranged wife. The trial comes more than 2 years after Emily Noble was last seen, the night of her 52nd birthday celebration, when she and Moore went out on May 24, 2020. Moore reported Noble missing, but he reportedly never helped with the search for his wife over the next few months. Then, 4 months later, several women found Noble's body badly decomposed in the woods near the couple's home. Her remains were in a kneeling position with a USB cord around her neck, tied to a tree branch. Authorities believe she was murdered and that her death was staged to look like a suicide. Moore was arrested last June and charged with felony murder and assault in connection to Noble's death. Before the jury was brought in on Thursday morning, attorneys had a dispute with the judge. Then one of the prosecutors stormed out. Take a look.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
She chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff will...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a...
Well, I'll tell you what, if you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
Once testimony did get underway, the defense rested after their second witness. He testified about a test he conducted with a crash dummy on the branch where Noble's remains were found.
After the static mass test, did you do a second test on the branch?
We did, and we called that the dynamic test, and we started by just hanging that fifth small female crash test dummy to make sure the branch suspended the dummy, and then we tried to lift the dummy about 6 inches and give it a little bit of a dynamic event so that there was some energy from gravity pulling on the dummy back down. I really wanted to try to mimic exactly how the remains were discovered to make sure the test was realistic as possible.
Was the branch able to sustain those 5 tests?
The branch did not fail, so I would say it sustained the 5 tests.
And Lisa, let's start with you here. Have you ever seen a prosecutor storm out of a courtroom? And legally, could the case even continue without anyone from the prosecution team present?
No, this was the first time that I've seen something like that. Complete lack of decorum. I totally understand what he was trying to say to the judge. He didn't want to continue. The judge was aware of her not being present for that period of time. And the only way that it would continue, obviously he cooled his heels and he came back, is to have somebody else pinch hit for the state's attorney who was not able to be there. Or the judge could simply say, let's have an adjournment and give them a day to resolve the issue.
Certainly made for a dramatic moment in that courtroom. Terry, turning now to the defense counsel in this case, how is she doing, and was this a good witness to call?
Well, I think she's doing a great job, and it was a very necessary witness. Diane Monash, the defense counsel, she's tried over 100 cases. In fact, She tried that case against Dr. William Hussell, who was the individual who was accused, frankly, of murdering his patients, and she got 14 not guilty verdicts for him. She teaches at Harvard Law School, so she is not a novice. Her opening statement detailed what she was going to show, and I like that. She didn't just sit back and let the prosecution fail. She said to that jury, I am going to show you what this case is all about. And this particular witness was important. That witness could establish that that tree could hold a body. And from a forensic standpoint, that is extremely important. The jury has to understand that this possibility, this suicide could have existed. And so that witness was crucial. And really all the defense needs to do is to make sure just one of those jurors has some sort of reasonable doubt. And by putting this witness on, she has established that. She's also said she's bringing other witnesses. And if she does that, I do think that the jury will be able to think about the fact that this case has doubt, and maybe that will be an acquittal or, maybe a hung jury.
Yeah, and certainly not a lot of evidence in this case. Thank you both, Lisa and Terry, and to our viewers, thank you for joining us here on Law and Crime Daily. We'll see you next time.